Mika. I am back. We're only coming here to talk about the topic. First of all, if you have a chance to jump in, jump in. If you don't, go ahead and check us out on hashtag replay. Our topic for today is a continuation of the conversation around W 2 versus 1099, the judgment that awarded, or the Department of Labor made a judgment to a staffing agency in Virginia requiring them to pay $7.2 million for misclassifying their employees back during the pandemic. So we have that post here in the group. If you want to see what other people's opinions are or takes on it, you can see it there. As always, thanks for being a part of our community. We're glad to have you. But also, don't forget, today is Mental Health Day, and we're representing with Wellness and Health. So as a healthcare professional, business owner, non-business owner, small business owner, women-owned business, it's always great and best to take out time to take care of yourself. So do that. Take out time for yourself, whether it's through massages, yoga, exercise, de-stress. Take a minute, take a step back, because without you, there would be no business. So, as always, welcome to our new members. We're glad that you came. We're going live today. I'm actually going live on my iPad today, which was a whole nother story. So, we're not going to get into that as well. We'll have some updates and some more information to share with you guys in the next coming week about NOSACON 2024. We're excited. And if you didn't attend NOSACON 2022, I'll drop the video that shares some of the things that we did over that weekend in Atlanta. So, feel free to drop your social media information so I can follow you. Over the last couple of weeks, we've had quite a few new people join our community, so we want to recognize you and show you a little bit of love. All right, so let's get into the conversation. So I posted a question, and the question was around this particular article that I read, and I'm just going to touch on 3 things about this particular article that I shared, which was the workers' classification opinion letter for temporary healthcare workers in post-acute care facilities. So the letter that I shared talked about a group of staffing agencies, and at the very end of the letter, it lists the staffing agencies out who sent a letter to the Department of Labor to classify healthcare workers working in post-acute care facilities as employees. So as W-2 employees, versus what we've seen, of course, in this instance where the staffing agency was sued as 1099. And some of that is a little bit of nuance, but a big part of it is around, hey, are nurses 1099 employees or are they W-2? And we had a great group of people respond and give feedback. So I just wanted to give it a little bit of clarification. So I'm going to take it back just a little bit. And one of my responses that I put up today was around the fact that as an employee or as a business owner, sorry guys, there's so much going on here. As a business owner, you really don't just get to pick what type of classification you give your employees, right? So if you start your staffing agency, say you have like administrative staff, you have nurses, you have CNAs, maybe you have an accountant, a business owner, things of that nature. You can't say, hey, I'm going to make my administrative staff exempt. I'm going to make my nurses non-exempt. I'm going to make them employees. I'm going to make my administrative people 1099s. That's not really how it works. So when you're putting together like your job descriptions and things of that nature around what the person is going to be doing, that's really the indicator as to where they fit in their level of classification and status. So you have 2 things happening a little bit at the same time. So you have your FLSA status, which is exempt and non-exempt, and then you have your worker status, which is, are you a 1099 contract? Are you a employee of the company? So that's really based on the type of work that you do, where you do that work, like the settings that you're doing the work, and how the work is dispersed to you. And I tell people the example that I give or have been advised on or told about is around the fact that if your work is dictated and supervised, then you're probably not a 1099. If you can operate independently, an example I would give would be like a lawyer or an attorney or an accountant, then there's a possibility that your work, that you can be set up in your company as a 1099 contractor. And then, of course, and I'll see if they have something on Department of Labor's website, but there's other pieces to that, and I think some of the confusion that's kind of been presented to many of us is around the idea of, hey, I've worked for staffing agencies or businesses where I was a 1099 contractor, but you still operated as far as like your tasks, your activities, your level of responsibility as an employee. So you operated as an employee, but was paid as a contractor, meaning no taxes were taken out. Some of the challenges around that thought process is that sometimes just because things aren't talked about or there isn't like immediate repercussions from doing it doesn't mean that it's right, or doesn't mean that you can't get caught up with it later on. So I've spoken to nurses. I know nurses who have attempted to do that and had issues behind that. And I've also, worked for companies where I was classified as a 1099. And then later that company was sued, much like this one in Virginia, because of that misclassification, and then had to pay back wages. Now, why people do it is a whole nother conversation. Like, that's something we would have to take on another day, because there is some thought process as to why an agency would do that. And if you have some comments or anything you want to share, feel free to do that. But a lot of it isn't based on what people think that it is. So essentially, I'm going to give a brief talk about what happened, and then give a brief talk about what the letter includes. So federal court in Virginia ordered a medical staffing agency to pay more than $7.2 million in back wages and liquidated damages to 1,105 workers it intentionally misclassified as independent workers or 1099s. The statement was given in January 27th of this year, or last year. The court orders follow an investigation from the Department of Labor's Wage and Hour Division, which determined that the staffing agency misclassified aides and nurses as independent contractors beginning in August of 2019. By misclassifying the workers, the medical staffing agency paid them straight wages, which is the other piece. So if you're only being classified as a 1099, you're not getting overtime. The medical staffing agency paid them straight wages instead of time and a half when they worked over 40 hours in 1 week. And there was some commentary in the post around the fact that it happens, sometimes that's what employees are looking for, but you have to think about it from a business standpoint of view. By running your business with 1099 employees, you aren't paying payroll taxes. You probably may not be paying unemployment taxes. And then, of course, your employees aren't paying those things as well. And depending on your circumstances, if it doesn't come back to you, it'll come back to the employee. So part of the piece that sometimes I think people are missing is that they want you to pay your taxes. So straight wages were paid on time instead of time and a half when they worked over 40 hours in a work week. And some of this can look a little bit different in California because they have a whole totally different situation when it comes to how overtime is determined. And then someone else asked if it would be a state by state. So like if the request of the letter, and I'll get to the letter in 1 second, was approved, would it be approved or have to get approved at each state? Like Michigan would have to say, yeah, we're going to do that, this state, that state, as far as the classification. So no, this is at the federal level. So like federal law says you have to pay your employees overtime pay after 40 hours, with the exception of a couple of states. It's not just California. So that's not something that you can opt out of. unless, of course, the person meets other classification requirements. The company was ordered to pay $3.6 million in back wages and the same amount in liquidated damages. The court asked Department of Labor, Solicitor of Labor to update back wages to the present day, which will likely bring workers a substantial increase. So in another video, and I want to say I did this video, it had to be like 2019. And I was talking about my experience working for a company that actually had this happen to them. So I don't think the settlement was as large, but it was the same circumstances. You worked an assignment. It was a short-term assignment. They classified me as a 1099. I got straight pay. Maybe on that particular assignment, I was working like 50, 60 hours a week. Sometimes when they might do like a 1099 classification, they'll also give you maybe a higher wage. So initially the position had typically ran for like $40, but now it's $50, but it's $50 as a 1099. So from that point, it was maybe 4 years later that the actual lawsuit had gone through and a settlement was paid out. But nonetheless, it happens. So it's something to be mindful of when you're starting your business, as well as just kind of understanding how business works. A little bit more things from the article was when employers misclassify employees as independent contractors and fail to pay workers their hard-earned wages, the U.S. Department of Labor will hold them legally accountable. So that was some of the feedback from the U.S. Department of Labor. They say, and it's happened for like a bunch of different healthcare staffing businesses, but it's also been a thing for other industries. So it's saying here in November, the agency ordered that owns a Las Vegas telemarketing company had to pay more than $1.4 million in back wages and liquidated damages for another similar transgression. So it's apparently a thing. And then it says, as Department of Labor combats worker misclassification, a number of states have addressed the issue. So sometimes your state can enact stuff first, which is sometimes how we see it. It kind of starts at the local and state level and then goes up to the federal level. So it's saying New Jersey, for instance, enacted a series of legislation in July that aimed to address misclassification by providing additional enforcement options to states and labor workforce to making it illegal for employers to misclassify workers for the purpose of avoiding insurance expenses. And that's the key piece. So even if that's not your intention as a business owner, that's what it looks like. So it's something that will hurt you. It'll cost you money and it just won't be worth it. So essentially the order of things, this is something that's been prevalent in our industry probably since I've been a nurse. I think it was about 2015 when I had, or maybe 2014 and 2015, where I had an instance where I worked as a 1099 with a health insurance company, a health staffing agency, but it probably was happening way before then, as I think a couple of people posted and shared online when we had that post in the group. So now let's move on to letters. So the letter is what I actually posted into the group, and I wanted to get some thoughts. So I'm not going to read the whole thing. You can check it out in the group. I'll probably drop it here in this video as well. But essentially, it was a letter sent to the Department of Labor's acting secretary, which is kind of the top level of a federal agency. And it says, we're writing on behalf of a coalition of technology-enabled healthcare staffing companies. So like I mentioned at the bottom, it lists out all the agencies that were a part of this coalition. We request an opinion letter from the Department of Labor concerning the classification of temporary healthcare workers who perform services in post-acute care facilities. And that's a key piece, because what exactly is post-acute care facilities? But in my understanding, because they didn't give clarification as to what they meant, but it's your nursing homes, your SNF, your LTACs, your hospitals, those types of things. I don't know that they included clinics or not. I don't think they wanted to, but that's usually not an issue seen in there in that type of environment. But they're saying the temporary healthcare workforce seeks confirmation on that nurses and certified nursing aides that are temporarily assigned, referred, or otherwise placed in acute care facilities by a firm, corporation, or partnership or other legal entity, including mobile applications or web-based applications, should be classified as employees of the agency under the Fair Labor Standards Act. So that was the floss of admonition based on existing federal regulations. So a little bit of thought on this part, is that during the pandemic, maybe a little bit before the pandemic, we saw a bunch of technology enter our market. And that was great. And it had good things and bad things. But with that technology entered the market was the concept that you could select your own shifts. Some of the apps that are out there, you can pick your own rate, right? You can say, oh, this is my rate. And they may require that you have your own business insurance, right, as an individual. And that would be the hiring process. And then, of course, the facility would look, or the hospital would look and pick you, right? You would show up. So from that process, one, that's the web-based mobile applications, where that's the whole way that you get hired. You go online, you submit all your documents, your titers, your application, your resume, you do maybe a test. You may also have a phone screening. I'm not sure that you even go that far into it. Do reference checks, things of that nature. And, you're essentially submitted to a facility healthcare system. And from that, we had two things happen. One, this opinion letter that's saying that, hey, those employees that are doing it through a mobile app or web-based platform are those individuals who are doing it are employees. They're not indeed 1099s. So what came from that was that those individuals were being classified as 1099 contractors, meaning no taxes were being taken out. The other piece was that we talked about it a while ago about there was this influx, and they may go hand in hand, maybe not. I wouldn't necessarily say it's hand in hand as much. There was a huge push for more staffing regulations around the idea that there was gross price gouging happening during the pandemic. Agencies, workers weren't showing up to shifts, these apps, and I'm not going to reference any of them. You guys have seen them all around social media, are not sending in qualified staff. There have been issues around it, whether it's time or last minute placements dropping out and things of that nature, because there isn't really like a wraparound like you would see in a traditional staffing agency. So what this letter is doing, because we also saw a letter around the travel nurse price gouging staffing regulations piece. What this letter is essentially asking is to provide clarification. So in an industry that never really experienced technology or technology being the way that you get hired, there isn't any specific language saying that it can't be done, which of course is why you're seeing it happen. But there also isn't any language to say that it can be done. So it talks a little bit about like what, traditional temporary nurse staffing agencies do. And then I'm going to talk in a little bit around the guidance. And then under the letter, it shows the reference as far as like articles. So the temporary nursing industry has grown rapidly in recent years, and temporary nurses staff are increasingly relied upon to fill gaps in traditional nursing staff. This is especially true in the wake of the COVID-19 pandemic, which exacerbated already existing nationwide shortages. We know that. Roughly 100,000 registered nurses have left the industry. Working conditions caused by the pandemic, and over 800,000 nurses plan to leave the workforce in the next 5 years for the same reason. By as soon as 2025, the nursing industry will have a shortage expected of 10 to 20% gap between nursing needs and available staff. These shortages have held a particular concerning impact on post-acute care facilities. As a result of the pandemic, the nursing home industry alone has lost 221,000 people, full-time caregivers. And in 2022, a survey found that 87% of nursing homes are experiencing moderate to high shortages. These shortages inevitably impact patient care, and limit new patient admissions. Staffing shortages are dangerous for nurses. Working in understaffed conditions takes mental, physical, blah, blah, blah. Okay. Okay, in essence, the temporary nursing industry has emerged as one of the leading solutions to address the nurse staffing shortage in post-acute care facilities. However, for temporary nursing staff arrangements to properly serve patients and nursing professionals, it is important that you ensure nursing staff are correctly classified as employees. So this letter is saying that they want the classification for nursing staff working for temporary agencies and travel capacities. Or local per diem, things of that nature, to be W-2s. However, it's saying, during the pandemic, more than half a dozen technology-enabled agencies elected to classify their nursing staff as independent contractors. And when you think about this from a business standpoint of view, I think it was Daniel, one of the notes has mentioned, it undercut your competition. So if I have a platform, like say I have the platform in the NOSA group, and it's a tech platform, and you apply and I'm offering $50, $60, but if you go work for an ABC staffing agency, they're offering $40, $45 because I don't have the overhead and additional expenses. I could do that because there isn't really any information outside. I'm taking a chance because there isn't any information, or my interpretation of the information is that it's okay to do. So you're undercutting your competition unfairly. That's person to person, but you really are undercutting your competition to be able to provide, staffing to that facility, and a little bit monopolizing the industry. So we've seen it. I've seen it. People say, hey, this is the agency to go with, or this is the tech product or web-based platform to go with. They have the highest rates. So now it's touching a little bit on historically. So historically, temporary nurse staffing agencies working in post-acute care have been classified as W-2. So that is true. However, during the pandemic, half a dozen agencies elected to classify the nursing staff as independent contractors. And here's the key piece: taking advantage of a market that was experiencing unprecedented demand and increasing labor shortfalls. As a result, the nature of temporary nursing work has not changed. We believe that a significant number of nurses and CNAs are being improperly classified as independent contractors due to the number of agencies that have chosen to operate under this model. Okay, so the coalition believes, and I touched on this a little bit, there are significant risks associated with the misclassification. Independent workers' status harm workers. Healthcare professionals who are misclassified as independent workers are denied employment-related benefits. Like I mentioned before, they're not paying payroll taxes, they're not paying unemployment taxes and things of that nature. They're not paying overtime. Access to employer-provided health insurance options, unemployment insurance, workers' comp, and other benefits. So that is true when you take that on. I do know some of the companies, even the one that I worked for years ago, did ask that you have, and you guys can kind of clarify, they did ask that you have insurance, but that there's no guarantee that the person has the insurance, so, or that it's, I'm just going to type this. What are your thoughts? So that's also a big thing. So of course they're asking for the misclassification. to be addressed. They're stating the reason. They're kind of touching on the fact that historically, that role has been filled by W-2 employees. And then finally, it says facilities that utilize healthcare professionals who are misclassified as independent workers may be faced with increased co-employment risk, misclassification of claims, audits regarding unemployment, overtime, payroll taxes, workers' comp, etc. And then what they do in the letter is the coalition references the Department of Labor judgment from 2022. So they touch on that, where they go into some instances of what happened and its impact. And then the last piece, which kind of ties into what I was talking about as far as the last piece around the money piece, right, is that they're kind of presenting it in a way that you're losing money too. So the opportunity for profit and loss, temporary nursing staff in a post-acute facilities do not necessarily have the opportunity for profit and loss to classify them as independent contractors. Workers may be classified as independent contractors if they exercise their managerial skills to obtain greater profits. On the other hand, a lack of exposure to potential losses is a strong indicator that workers are employees. Temporary nursing staffs are not in the business for themselves. Temporary nursing staff cannot increase their profits through the exercise of managerial skills and can only earn money by working more shifts. The rates they earn for shifts are set by the agencies. They do not have the opportunity to generate new business or identify new clients, facilities, and are relying on the agencies to connect them with the workforce. Temporary nurses staff do not have exposure to potential losses and are paid directly by the agencies, regardless of whether the client facilities have already paid the agencies. And then they talk about the investment in equipment and materials. So they're really building a case essentially around the fact of what a 1099 is in a healthcare space versus what is actually happening. They also referenced another court case, Brock versus Superior Care, where the Second Circuit held that nurses working in a nurse registry, many of whom had worked under 13 weeks should be classified as employees. The court noted that the fact that these nurses are a transient workforce reflects the nature of the profession. It is important to note that this inquiry does not examine the permanency of a relationship between a nurse and a specific facility, but instead looks at how permanent the relationship is between the nurse and the agency. Okay, so they did all of that in the letter, and I encourage you guys to read the letter. If you hit the highlights, you'll get the gist of it. That's kind of why I'm here, to kind of help get the gist of it. But essentially, they want to kind of move those types of companies, because I'm not going to say they're agencies, because I believe they don't call themselves agencies, but those types of companies out of the way, or have them reclassify their workforce to make them W-2s. And one of the things that I think is important before I wrap up here is that you don't want to kind of, miss kind of the key pieces around it. So like, everything happens for a reason. I think this is not that much more surprising than we saw the staffing regulations push at many state levels and get approved in quite a few states happen. So more of it for me in sharing it is kind of understanding the reason behind it. And I'll touch on that at the very, very end. But through the letter, they talked about what was wrong, why they shouldn't do it, what has been done in the past, why it's a problem. And then, of course, here on page or section 8, they say the coalition would like to propose rulemaking on worker classification. So they share what they think is appropriate language around this particular classification. So the coalition is aware that the Department of Labor recently issued a notice of proposed rulemaking regarding employee classification under FLASA. The coalition does not believe that anything in the rulemaking alters the analysis for agencies under FLASA. In fact, the proposed rule will only strengthen the existing argument in favor of classifying temporary nursing staff as employees. The proposed rule offers several points of clarification that supports the coalition's position, and they listed there. And in conclusion, the coalition believes that the temporary nursing staffing who are connected to nursing shifts at post-acute care facilities through agencies must be classified as employees under the FLASA and seeks guidance with your response to our position. We understand that the inquiry, in fact, we understand that the inquiry is fact intensive and no one factor is dispositive. However, assuming the facts presented above the materially true and agencies that classify nursing staff as independent contractors compliant with FLASA, or there are elements of the forging description that indicate, as a coalition believes, that temporary nursing staff at acute post-acute care facilities must be classified employees. So, of course, they put all that there. They listed out the, the main people that were involved in creating the letter. And then they, on the last page, which is page 10, listed out what other companies were endorsing it. Ironically, a lot of them were, some of the large companies that you've heard of before. There are a few ones that I'm not that familiar with, but I would say like 90% of them I've heard of before. And, kind of interwork together or sister companies of each other. So what's my take on that? So my take on this situation is very similar to what my take on was around the staffing regulation stuff, which is you have to get involved in the process beyond your neighborhood. The reason that they're sending the letter, much like the other letter that got sent, is because they wanted to be changed. They brought together the individuals and decision makers to kind of come to one accord on that. They did the research on that. And I know as small business owners, sometimes it's challenging, but what sometimes you don't realize is that having one person say, hey, I don't agree with this, really does have an impact when you're talking at the state and local level, or I want you to look into this. So when there was a lot of conversation, and I don't know how this will go because this is a little bit different, but when there was a lot of conversation about implementing heavy staffing regulation that requires high interest, high fees to submit your application, extensive requirements, reporting requirements, there were a few NOSAs and other agency owners that attended information sessions, to push back on the idea of doing this because it impacts your business, right? So like a lot of the companies listed, and I'm not really taking a side versus just kind of stating facts, a lot of the companies listed aren't small business owners in the communities that they live and work. They're big businesses. Many times they may operate their business, but a lot of their, they may work with people in the community, but a lot of times they're operating their business like in Nebraska, but they're sending nurses every place else, or healthcare professionals every place else. So, or the clients that they work with are every place else. So when you think about, hey, I want to start my business and I want to do these different things, you have to understand, one, that it's just not about the fact that our business is changing and we're seeing a lot of different things that are impacting our ability to sustain in the business, but also what else am I doing, or is there anything else more that I can be doing to make sure that, hey, if a group of healthcare professionals come together and make a decision on something or a recommendation, because essentially it's a recommendation, I want to be, one, aware of it, but also, hey, I want to make sure the person that represents me and my community understand the impact that it may have on my business. And that's ultimately the piece that's always hard and tricky with a community like you guys. As always, kudos to you guys, is that you have to factor in the impact that things like this or anything can have on your business, and be willing to show up at sessions, or, write a letter yourself, or get together with a couple of nurses and do something. Because even if it still happens, which, there's a likelihood that that'll happen, that you've done your part, and that you've taken into consideration that it's a full package. So like, owning a business isn't just like, hey, I own my business here at the house, I do my thing, I send my people out, that's all that I do. It's a bigger piece to owning the business and actually getting things that support and improve your business into play. No different than the staffing regulations, no different than the ratios. And I'll do a post about that probably tomorrow. Those are things that groups came together and decided upon and pushed it forward. One of the differences I will say as I wrap up here is, from this and staffing regulations and even staffing ratios, is that this is kind of paired up to me with the staffing regulations in a lot of ways. And the staffing regulations, unless it's, taken to the federal level, is something that was only at a state level that was being managed when we talked about it last year. So if you guys have any ideas, we definitely want to support and do what we can. This is definitely not our forte, but it's a part of doing business, any kind of business. When changes are made, whether it's, we've seen stuff like that happen with Airbnb, when, specific states made changes around what you could and could not do. If you don't show up to the sessions and the meetings, you don't write the letters to your state and local officials, things will just happen, and you'll just have to adjust to it. So I encourage you guys to, even though you're small business owners, maybe do a little bit more, or just get more involved as far as education, because that's kind of where you go from having a business that's around for 4 or 5 years, or even thriving during the pandemic, to where many of people have expressed that they're struggling. Even though the struggle can be twofold, as far as the struggle is partially the employees, but the struggle is definitely real around what technology coming into our industry brought, as far as how we hire and move people around. As always, I hope I explained it. I try to keep this video short and sweet. I think I went for about 20 minutes, but we'll drop another presentation that'll walk you through a couple of things and kind of talk about the staffing regulations, as that's still a thing, the staffing regulations, staffing ratios. This piece is kind of impacting our industry. At this time, we don't have any plans to do more than just provide the education, or provide you guys with the education and information. But if we decide to change out and we want to do something more, or you have suggestions on how we can support, let us know. Or if you're in a state, especially for the staffing regulations, where things have changed, share that with us so that we can share it with the community. So that as people are entering the industry or moving from state to state, they're aware. Thanks for being a part of the community. Thanks for hanging out here. If you haven't gotten a chance, go ahead and join. Go ahead and check out our YouTube channel, where a lot of this content that we push here is going to be moved over, because Facebook only allows you to keep stuff for a short period of time. So as always, thanks for being a part of the community. I hope that helped unpack a lot of things. Like I said, we'll do another video with a presentation